What does a 2020 Georgia Supreme Court case have to do with a 1900 case about a dead officer? Plenty. A report about a case decided by the Supreme Court of the state of Georgia this past December highlights the importance of knowing your rights. Now, in the 1900 case the Georgia justices used in their opinion, we see that this knowledge can have life or death consequences. Both cases show the importance of knowing your rights and being prepared to assert them, especially in the face of government actors. So we'll look at that case next on the Constitution Study.
One thing you have to know wherever you make your stand came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study. This is where we read and study the Constitution. We teach the rising generation to be free, and I'm glad you could join me. Now, as always, I'm going to point you to that website, constitutionstudy.com, which you can find all the information about the Constitution Study, my articles, my videos, my podcast, everything you want to know. But I've got a special offer going on for the next month or so, so stay in touch. I'll talk to you about it at the end of the program, but please check out that website and we'll talk about what you can find there in just a few minutes. But right now, let's get back to this story about a Georgia Supreme Court case. Our story begins with the Georgia case, Glenn versus the state. In the evidentiary hearing conducted by the trial court, both testimony and body camera evidence was presented. Quote, on May 3, 2018, an Athens Clarke County police officer responded to a suspicious person call in the area of Oglethorpe Elementary School shortly after students were dismissed at 2:30 p.m. The responding officer drove around the school property in his patrol car, and for a few seconds he saw Glenn walking on the inside of a line of trees and shrubbery that bordered the road behind the school. The officer testified that he radioed to his dispatcher that he was getting out of his patrol car with a subject matching the description given by the initial 911 caller. The responding officer approached Glenn and called out to him, "Let me talk to you real quick." Glenn asked if he was being detained. The officer responded yes, ordered Glenn to stop walking and to sit down, and radioed for backup. Glenn, who remained standing, asked the officer why he was being detained and said, "I'll tell you my name. It's Christopher Glenn. I'm walking home." The officer told Glenn that he was conducting an investigation and that if Glenn moved, he would be charged with obstruction, and if he tried to flee, the officer would use force if he had to. Now, shortly after backup arrived, Mr. Glenn was handcuffed, searched, and told he was going to have to take a seat in the patrol car. Mr. Glenn asked, "I want you to tell me right here, what am I being detained for?" One of the officers told him for suspicion of a crime, a sexual assault against a minor. Mr. Glenn told the officer that he was dehydrated, so medical personnel were called, and Mr. Glenn was placed in the treatment area of an ambulance. The supervising officer ordered Mr. Glenn to be removed from the ambulance, stating he would be evaluated by jail personnel. Mr. Glenn refused to exit the ambulance, and the officers physically dragged him to the door, where Mr. Glenn flung himself toward the officers, headbutted the supervising officer, then went limp. When the officers tried to get him into the patrol car, Mr. Glenn kicked and struggled, falling onto another officer and knocking him down. Continued attempts to get Mr. Glenn into the patrol car were met with similar resistance. At one point, the supervising officer knocked Mr. Glenn to the ground. At another point, Mr. Glenn damaged the door of the patrol car. Eventually, the officers were able to get Mr. Glenn into the patrol car, where they tied his legs, secured his feet to the floor, and then took him to jail. A day after his arrest, a warrant was issued for Mr. Glenn's arrest for violating the conditions of his probation by committing new offenses: loitering and prowling, obstruction of a law enforcement officer, and interference with government property. 2 weeks later, Georgia filed a petition to revoke Mr. Glenn's probation because of these offenses. At a hearing on the revocation of Mr. Glenn's parole, the state of Georgia argued that Mr. Glenn committed the offense of loitering and prowling by walking along the wooded edge of an elementary school as the school was being let out. That Mr. Glenn committed the offense of obstruction and interference with government property by physically resisting in multiple ways at multiple points in time while being detained pending further investigation of the reason for the officer's dispatch. The state also argued that even if Mr. Glenn's arrest was unlawful, meaning he did not commit obstruction, he was still guilty of damaging government property. Mr. Glenn argued that the evidence shows that the responding officer did not have probable cause to arrest him for loitering and prowling, thereby making it legal for him to resist an unlawful arrest. Now, when the case went to trial, we read, quote, The trial court determined that the evidence did not support a finding by a preponderance of the evidence that Glenn had committed the offense of loitering and prowling. Specifically, the trial court found that on May 3, 2018, the officer did not observe Glenn in a place at a time or in a manner not unusual for law-abiding individuals, and found that there was no evidence of any circumstances of the type listed in the applicable status as to warranting alarm for the safety of persons or property in the vicinity. The trial court noted that the officers involved failed to give Glenn, prior to arresting him, an opportunity to explain his presence and conduct so as to dispel any alarm or immediate concern which would otherwise be warranted. The trial court also determined that the evidence did not support a finding by a preponderance of the evidence that Glenn had committed the offense of obstruction because there had been no basis to arrest Glenn for loitering and prowling. Game, set, match, yes? No. Quote, but the trial court found by a preponderance of the evidence that Glenn had committed the felony offense of interference with government property by damaging the patrol car. Specifically, the trial court found that even though Glenn's arrest for loitering and prowling was unlawful, he had no legal justification for damaging government property once he was in handcuffs and sitting in the patrol car. Now, the case was appealed, but the Georgia Court of Appeals found that while Mr. Glenn did have the right to resist with force his unlawful arrest, the amount of time that lapsed between being placed in the patrol car and damaging the vehicle was too long, and that since his reaction was not immediate to his arrest, the damage was an intentional act. At this point, the case was appealed to the Georgia Supreme Court, whose opinion went into a lengthy description of the history of legal resistance to unlawful arrest, and the opinion of the court read, quote, generally, under the common law, a person cannot be punished for fleeing from or physically resisting an unlawful arrest or escaping from an unlawful detention, so long as the person uses no more force than is necessary to achieve such purposes. See United States v. DeRee. The Georgia court based its opinion on the case United States v. DeRee, which in turn was quoting a 1900 case, Bad Elk v. United States. The Bad Elk case questioned whether someone could be charged with murder for using lethal force to avoid an unlawful arrest. Reading from the syllabus of that case, quote, 3 policemen in South Dakota attempted, under verbal orders, to arrest another policeman for an alleged violation of law when no charge had been formally made against him and no warrant had issued for his arrest. Those attempting to make the arrest carried arms, and when he refused to go, they tried to oblige him to do so by force. He fired and killed one of them. He was arrested, tried for murder, and convicted. Now, interesting, during the trial, the judge charged the jury, quote, the deceased, John Killsback, had been ordered to arrest the defendant, hence he had a right to go and make the attempt to arrest the defendant. The defendant had no right to resist him. It is claimed on the part of the defendant that he made no resistance, and he was willing to go with the officer in the morning. I charge you, of course, that the officer, John Killsback, had a right to determine for himself when this man should go to the agency with him. In this connection, I desire to say to you, gentlemen of the jury, that the deceased, being an officer of the law, had a right to be armed, and for the purposes of arresting the defendant, he would have had the right to show his revolver. He would have had the right to use only so much force as was necessary to take the prisoner, and the fact that he was using no more force than was necessary to take the prisoner would not be sufficient justification for the defendant to shoot and kill him. The defendant would only be justified in killing the deceased when you should find that the circumstances showed that the deceased had so far forgotten his duties as an officer and had gone beyond the force necessary to arrest defendant and was about to kill him or inflict great bodily injury upon him, which was not necessary for the purpose of making the arrest. In short, the judge all but ordered the jury to find the defendant guilty because, as a law enforcement officer, John Killsback had the right not only to arrest the defendant, but to use force to do so, even though the order he was given was unlawful. In other words, this judge instructed the jury that you, as a citizen, are a subject to the whims of law enforcement, even if their actions are unlawful. Now let's examine that claim for just a minute. The Fourth Amendment reads, quote, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. You have a right to be secure from unreasonable seizure. In neither the Bad Elk case nor the Glenn case did the arresting officer have a warrant or direct observation of a crime. In both cases, we see law enforcement officers ordering the arrest and seizing people without any legitimate reason to do so. And in both cases, we see an expectation that citizens are subjects of law enforcement, expected to shut up and do what they're told, even if what is happening to them is illegal. In the Bad Elk case, we further see judicial malpractice when the trial judge tells the jury that a law enforcement officer has the right to make an illegal arrest. Thankfully, in both cases, the courts eventually came to the right opinion. What can we learn from these two cases? Well, first of all, we should recognize that we, as free citizens, are not subjects of the state. A government official, even a law enforcement officer, does not have the right to make an unlawful arrest. That as free citizens, it is our right, or as I would say, our duty, to resist such unlawful seizures with all of our abilities. Now keep that in mind when you see videos of people standing up for their rights, breaking into their own businesses that were illegally boarded up, or resisting arrest for not wearing a mask. Second, we need to recognize that the courts are not the solution to all of our problems. Yes, in both these cases, the correct opinion was eventually handed down, but that was only after years of fighting for their rights. Imagine yourself at the defendant's table when a judge instructs the jury that you do not have the right to defend yourself against an illegal arrest. Then remember all of the court opinions that said government can infringe on your rights if they have good reason to do so. Lastly, these cases show how important it is that we know our rights and how to defend them properly. Not simply by asserting your rights with law enforcement, but having the ability to assist in your defense should you be the victim of unlawful actions by government officials. So we have two cases, almost 120 years apart, dealing with the same basic question. Do a free people have the legal authority to resist unlawful arrest? Does government have to have a legal reason to seize you before they can actually do so? In other words, does the Fourth Amendment matter? Now, I haven't done the research, and I'm curious what happened to the officers in both of these cases, because technically they broke the law. In fact, they actually broke federal law. 18 U.S.C. 242 says it was a crime for them, under color of law, to deprive their victims of a right protected by the Constitution, specifically the Fourth Amendment protection against unreasonable search and seizure. But it's important also to notice that not only did these men resist lawfully, but hopefully they were able to participate in their defense, to recognize the rightness of what they had done and help in their own defense. So that's why it's important that we read and study the Constitution, that we know what our rights are. That's why I'm taking some time this summer and I'm traveling the country helping people know what their rights are. Head to constitutionstudy.com/tour and check out the Knowing Your Rights tour. I've got about 5 or 6 stops right now, and I'm looking for more. So go to that. You'll see what I'm talking about, where I'm teaching people to know what their rights are and how to defend and assert them. You can see where I'll be stopping and when. And please, if you're in the area, I'd love to meet you. In fact, I'd love to meet you face to face. I'd even love to shake your hand. Now, if I'm not coming to your area, well, please, there's a form in the bottom. You can request I come speak to your group. It doesn't need to be a big fancy event. It could be a bunch of people sitting around a table having a cup of coffee or having lunch, or just, as one group is doing, we're meeting in the back of a bakery. That's all it has to be. Fill out that form. I'll be more than happy to see if I can make your event part of my itinerary. So check that out, find out more. The other thing I want you to know is, see, right now, we're between two very interesting holidays. Last Monday was Memorial Day, and I did a special message about it, and I didn't talk about this very much, but I want to make a point for you today. See, between Memorial Day and Independence Day, I'm trying to get people to be more engaged in studying the Constitution. So here's what I've done. Go to constitutionscholars.com. If you have not already registered, register today. It is absolutely free. When you register within 24 to 36 hours, I will email you a coupon for $5 off the store. So you get the account, which means you get access to the library, the webcast, the videos, all that information you get absolutely free. You get access to all the groups, all the free groups where you can meet others in your state, and we can even set up some groups based on different issues and topics. You can participate in the scholars events that I'm setting up this summer. all absolutely free. And as a thank you, I'm going to give you a $5 coupon should you want to buy a book or a class or a t-shirt from the store. But there's one other thing. See, everyone who registers between Memorial Day and Independence Day, their name goes into a raffle. I'm giving away a copy of my book, How to Read the Constitution in 30 Days. It's a daily devotion meant to make it easier for people to get started reading, or for people like me who like to read the Constitution regularly, to make it a regular routine part of their lives. So that's going to be given away. I'm giving away a signed copy to one of those people who register between Memorial Day and Independence Day. By the way, if you're already a scholar, thank you very much. Here's my challenge to you, because I do have people that are already part of the scholars. I want to give them something too. So here's what I'm going to do. Everybody who posts new content on the scholars, within the scholars, there's groups, and you can go in and you can start a discussion in a group. Just go in there and go to the discussion tab and start a new thread. Everybody that starts a discussion, that posts something original on that site. And I don't mean you originally wrote it, meaning I don't mean just commenting on someone else's post. I mean, you post something new. Every time you post, that is an entry into a raffle. I'll be giving away a signed copy of my book, The Constitution Study, probably shortly after Independence Day. So that's many ways. If you're not a scholar already, go there, register, get your $5 coupon, and your chance to win the How to Read the Constitution in 30 Days book. Once you're there, or if you're already a scholar, post something. Find a news item. Ask a question. Do something in one of the groups, and you get entered for my copy of the Constitution Study, both of which will be signed, both will be mailed to you shortly after the Independence Day holiday. So that's my challenge to you, to get you to engage, to not simply sit back, not simply listen, but to actually engage, whether it's asking a question or posting something you may find interesting. You may also find other posts up there that you want to comment on, but I'm really looking for the new content. All of that to help people get involved and engaged. And obviously, if you have a question, ask it. I'm always willing to answer whatever question I can. So that's the deal. Between Memorial Day, when we remember those who died for our liberties, and Independence Day, when we celebrate our independence, to me, that's the perfect time to kind of step up our game, to honor those who have died to protect our freedom by defending our freedoms today, to honor those who pledged their lives, their fortunes, and their sacred honor by pledging to spend a little bit of time, finding a little bit of knowledge, and then figuring out how we can apply that in our lives. So please check those out. And again, ask any question you want, and I'll do my best to answer it. Share these videos. Share this with friends, share this with family, share this on social media, and then please join me next time for the Constitution Study.